Can you read to me the nameplate?
Judge Ebony K. Williams.
So the only thing that matters in this particular courtroom is how I see it. I am from North Carolina by way of Louisiana with some West Coast cool and a New York edge. Do we have a problem, ma'am?
No, I don't, Your Honor.
Equal justice is all about the most important values of our country: freedom, integrity, and those are the things that I'm striving for. Ma'am, you run your household, this man gets to run his. I decided to become an attorney and pursue the law. I wanted to be a voice for the voiceless. This court cannot hold this woman accountable. People from all sectors of life, black, white, purple, gay, straight, queer, and that's what equal justice with Judge Ebony K. Williams is all about.
Amanda Burke claims her neighbor harassed her by putting a racist statue in their shared yard. Ryan Chadwick says he refused to remove it because the statue is historic art and a family heirloom.
Ladies and gentlemen, I see I've got Amanda Burke here as my plaintiff, Ryan Chadwick as the defendant. Ms. Burke, you're suing the defendant for $7,500. You're saying that he's caused some damage to your property. Tell us why you're in court today.
Correct. I'm in the very awkward position of having to sue my next door neighbor. He has decided to display a racist statue in his front yard. Unfortunately, our yards are connected because we share a lawn. So we're in a townhouse. My house is on the right and his house is on the left.
Okay, ma'am, go ahead and present that along with all your evidence folder to my bailiff here so we can all be looking at the same thing.
Okay.
Thank you.
Thank you.
No problem.
Thank you, Elijah. Now let's take a look and see what we got going on here. That's your house with the reef on it, ma'am?
Correct, yes.
Okay, and then that's your house beside her?
Correct.
That's correct, sir. Okay. And this little figure here, this is what we call a lawn jockey. This is essentially something in blackface, highly offensive, anti-black trope that one would think in 2020-something we would know better than to amplify. Anyways, that is residing in front of your property by your choice.
That is
correct. And you're saying, ma'am, that it's also living on your property? Is that the argument, ma'am?
Yes, it's right on our property line. It's almost intentional that he placed it right there. And my whole family's suffering because of it.
Suffering in what way, ma'am?
We've had vandalism. I mean, we've had trash thrown in our front yards. I've had strangers come by in their car and roll down their windows and yell comments at me, offensive comments at me because...
What have they said to you, ma'am?
Well, for one, they've called me a racist. They've made comments about the statue being mine, and it's not mine, but there's no way to distinguish who it is because it's right in the middle of our yard. And when I confronted him about it, I said, can you please move that statue into your home, or can you please move it further to your side of the yard? And you refused to do that.
I do want to be clear. You're suing for $7,500 for emotional distress, and I do see that you have presented the court with some medical bills here.
Yes, ma'am.
So you've had therapy.
My son has had therapy.
This is your son. How old's your son, ma'am?
He's 9.
And so he's been harassed as well?
Oh, yes, he's been bullied to no end. He came home crying one day asking, he said, Mommy, am I a bad person?
Okay, and let me see, this is a letter you've presented the court from a psychiatrist. Please accept this as official proof of my statement. Tommy has been diagnosed with acute stress disorder. So this is your 9-year-old son.
Yes.
And anxiety, and he's been in her care.
This moment shifts the entire case. Emotional distress claims can be difficult to prove, but when medical documentation enters a record, everything changes. A licensed psychiatrist diagnosing a 9-year-old child with acute stress disorder elevates this from discomfort to clinical harm. Courts take special care when minors are involved, especially when emotional injury can be directly tied to an external stimulus. The judge isn't just listening as a neutral party now. She's evaluating causation. Was the statue a contributing factor? Were the reactions foreseeable? And most importantly, was the harm avoidable? These are the questions that transform a moral argument into a legal one.
This is quite devastating, I imagine, ma'am.
It just completely goes against everything we believe in.
Well, let's get to it, Mr. Chadwick. Why have such a statue in your yard, and what is your statement to the world when you put that in your yard? What are you trying to communicate?
Thank you, Your Honor. First of all, I'd like to say that this piece, to me, is a historical piece of art. It's been in my family for many generations. A couple of hundred years. I actually received it from my great-grandmother at the time. Now, we were rice farmers out there, and we
Y'all
always
were
had
rice farmers? Did y'all
Yes.
have a plantation, sir?
Well, ma'am, we never called it that. We just grew rice.
Did y'all grow rice, or did y'all have enslaved Africans and people of African descent growing rice? No, because we're in court. We're going to tell the truth today. So
That's wonderful.
Right.
I'm Czechoslovakian, and we came to America as farmers in
Okay.
the early 1900s.
I'm trying to determine, sir, if your family, because you're talking about multi-generations
Yes.
of legacy, had any relation or contact with Black Americans in that region.
My grandfather purchased the land in 1911.
Right?
And he didn't buy it with people or anything like that. He
I
just bought-
understand that. That's a sharecropper is not a slave, sir. Do you know the
Okay,
difference
so
between
we
a slave?
bought it
Sir,
with-
sir, I'm
with-
actually speaking. Do you know the difference between a sharecropper and an enslaved person? If you don't know,
I cannot
say you-
define it. No, ma'am.
So then you don't know.
This line of questioning isn't about humiliation. It's about accountability. Judges often press witnesses when their testimony lacks clarity or certainty. Here, Judge Williams is establishing a critical point. The defendant cannot definitively separate his family history from the racial symbolism embedded in the statue. That uncertainty matters. If you don't understand the origin, you cannot dismiss the harm. This isn't about rewriting history. It's about recognizing it fully. And courts do not reward selective understanding.
Right.
Okay, so let's just leave that one there. You are not sure.
Coming up on Equal Justice.
Do you see a correlation, sir, for you? Does this have any connection to Black American identity or people?
If there is, I was not aware of it.
And later,
I incurred all the expenses for the dogs, vet bills, food, medicine for them and everything, and I took care of them. I had to take them to work with me because I couldn't leave them at home.
Oh, wow. So they really became y'all's dogs.
if you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. This is Equal Justice. Equal Justice is back with the case of Amanda Burke, who brought Ryan Chadwick to court over a racist statue.
As you talk about and acknowledge your uncertainty as to your family's correlation and proximity to actual people, that this figure, what you called it, historic art, is supposed to represent.
Correct.
Okay, now go ahead.
So I received this from my great-grandmother, and I have no children. I'm a widower, and
Okay, well, I do apologize for your loss there, sir, but go ahead.
thank you. And so I've just kept it in the family because it's just been there. And at the farm, it's always been out on the front, on the lawn like this for my entire life.
And
as
when
far
did
as
you
I know.
move into this townhouse? Because this is not the farm.
I have been there about 8 months.
Okay, so this is since your wife has passed on?
Correct.
Okay.
I retired and moved into a building by myself. Correct.
And when you see it, what do you see, sir?
I just look at it as a person. I don't think of it
What
anything
kind of person, sir?
like a gnome, just kind of a lucky charm thing. And I always thought it was pretty.
Is
and
it a
as
person
kid,
or is it a gnome? Because those are not synonymous.
okay, well, that's how I look at it. And I've always known it's got some value to it. So as
What's the value? Like
well,
you like
I've
some
seen them sell for
monetary?
a couple $1,000s to
Okay.
even more. I
Okay.
don't know that one in particular.
So you see this as, you call it a lucky charm?
Yeah, like a lucky charm, correct?
Okay,
like a
what's
bracelet.
the nature of the luck, sir? No, because I want you to explain yourself. Because if I was to say it's a four-leaf clover, you could talk to me about the Irish or Celtic legacy. Like, come on now. Ain't nobody a kid in here. Nobody's gonna play these games with
Okay.
you, sir. So what are you seeing that's lucky about it?
Okay, well, clarifying, I'm not playing games. I'm being very honest with you. But the fact is that we always, as a family, when he was out, our rice would grow.
Does
And
he have a name?
No, it's just a statue to us.
Okay. So a nameless statue
Correct.
that happens to be black. Do you see a correlation, sir, for you? Does this have any connection to Black American identity or people?
If there is, I was not aware of it.
Okay. How did you communicate to him, ma'am, that this was an issue for you and your family?
At first, we were on good terms before the statue went up. I brought over like a basket with wine and cookies and everything.
Okay, let's
and
get to when it wasn't good terms.
Oh, I'm sorry.
Okay, so.
And then,
Yeah.
when it went up, that's when things started to go south, and I came over there and I'm like, hey, I don't feel comfortable with this in my front yard.
So you said this directly to him. You recall this, sir, right? She came to you
I do, yes.
in person. Okay, and then what was your response, sir?
I just said, well, it's my lawn. I can put on my lawn what is, kind of decorative to me. And I never thought of it. I never thought of it as hate. Like,
Sir, I'm not asking you any of that. I'm asking you, when your neighbors said it was a problem for her and her family, what your response was. And you're telling the court, what I hear you telling the court is tough luck, basically. You said you were not going to move it. That was your response.
well, I have to clarify a little bit, if you don't mind. I want you to note the picture that she gave you is not exactly our houses, because when that picture was taken, she had taken down her love for love flags all over the front of her house, which I never complained about.
You said love for love. So that was that, ma'am, a pro-LGBTQ plus type of message?
Yeah.
Okay.
Yeah, essentially.
Rainbows and such?
Yes,
Okay.
yes. Mhm.
Okay, sir, that's not a secret. We don't have to whisper that.
Well, I know, but I just want you to know she has
Yeah.
things in her yard
that
that
are representative of social and political statement.
It's fine. I
And it's
never
fine.
complained.
Here's where the defense makes a common but legally flawed comparison. The presence of pride flags is not equivalent to a racially charged caricature. The court immediately distinguishes between expression that affirms identity and symbols historically used to demean it. Judge Williams makes it clear. Harm requires evidence. The plaintiff provided medical records, harassment accounts, and emotional impact. The defendant provided none. Courts don't rule on hypotheticals. They rule on injury.
Yes.
I never complained. I'm
Were
not
you
one of these.
harassed because of it, sir? She's showing injury, sir. Do you have injury to show for her flags?
No, I.
Do you
was
have any
not injured.
evidence to show the court, sir? Do you have an evidence folder?
No, I just came because I was told to come.
Okay, yeah, you were subpoenaed. Okay, so is there anything else you want to offer, ma'am, before I make my ruling?
Yes, I just want to say my family is in crisis right now. We're afraid for our safety. We're embarrassed, and we're afraid to leave our own house. And I think that's unacceptable that that it's legally allowed for him to display this item. And I just hope that it can come down.
Okay, and your final words to the court, sir? Because you see how much distress that she's in.
I just want to say that in today's world, we have people that are calling themselves social justice warriors. And they do things like pull down flags and statues that are hundreds of years old. And I just have to ask, I mean, are they going to take down the White House? They're going to take down the beautiful mansions here in the South that had slaves, I guess, because they were there? They're just buildings to me.
Don't
and
worry
they're
about
historical.
it, sir. I'm actually going to tell you what's going to happen next. This court doesn't concern itself with your personal beliefs, sir. That's your demon that you can live and die by. But this court does concern itself with is the right that this woman and her family has to the peaceful enjoyment of their legally owned property.
The judge's ruling is precise and powerful. She awards a maximum allowable amount, not as punishment, but as recognition of harm. This is civil justice doing exactly what it's designed to do: compensate injury, affirm rights, and deter future harm. Importantly, the judge separates personal belief from legal obligation. You are free to believe what you want, but you are not free to harm others without consequence.
As it stands today, I find in favor of the plaintiff for the full value asked. It is the maximum I can give. I wish I could give you more. As it stands, I'm going to give $7,500 for your pain, your suffering. I wish you, your husband, and your child all of the healing and closure that you can give.
Thank you.
Sir, I wish you an education, and I wish you grace and humility as you live out the rest of your years. So ordered, that is my ruling.
All rise.
Judge Ebony has ruled in favor of the plaintiff. The defendant is ordered to pay $7,500.
Just glad it's going down. Sorry, but I don't believe that way.
You're invited to my dinner tonight with your family.
You've had your day in court. Please follow me.
Coming up on Equal Justice.
Because this is important for my ruling, that this stayed in the group, this stayed in the text chain. This
Yes.
never got physical. This never came to any fruition.
Yes.
This is Equal Justice. Taylor Burton claims that her boyfriend dumped her, then only gave her 48 hours to remove her dogs and belongings from their apartment. Michael Owens says he kicked Miss Burton out because she cheated.
I see I've got Taylor Burton here as my plaintiff and Michael Owens as my defendant. Ms. Burton, I see you are suing the defendant for $778. Tell us why we're in court today.
Yes, Your Honor. So I'm suing my ex-boyfriend because he broke up with me in a quick situation and caused me to have to be forced to move out of a co-living situation. He threatened to get rid of all my belongings, including my 2 dogs. And I had to pay expenses to get out there in an emergency because I was in LA at the time and he was in Denver.
Okay. How long were you two in a relationship?
We had been in a relationship for 3 years at the time.
Oh, so this was very serious long-term relationship. You were living together?
Yes.
How long had you lived together?
I would lived in LA half the time and then with him the other half the time.
So you were kind of, I guess maybe not bi-coastal, but some version of that.
Yes.
Okay.
Yes. And that was at about 2 years. We decided to start doing that because he couldn't travel for work. I had to work in LA, but since my job was a little bit more flexible, I paid a lot of money to go out and see him because I loved him and I wanted the relationship to work.
Let's hear from you, sir.
Your Honor, it wasn't just her decision to have the dogs stay with me. I wanted them to stay with me. I knew it was easier. I incurred all the expenses for the dogs, vet bills, food, medicine for them and everything, and I took care of them. So I had to take them to work with me because I couldn't leave them at home.
Oh, wow. So they really became y'all's dogs?
Yes.
Is that a fair assessment, ma'am?
I would say so. That's correct.
Okay, so you care and are invested in these dogs as well. So why is she saying, sir, that let's back up also, why did y'all break up?
Coming up on Equal Justice.
For me, you know, you hit a certain age and you date with intention to be married to somebody, right?
Okay, come on, grown man.
And, you know, cheating from the heart is still cheating.
This is Equal Justice. Equal Justice is back with a dispute between Taylor Burton and Michael Owens over a last-minute move.
I bought her an iPad, so she had a little bit of something on her own if she wanted to, I don't know, watch a movie, play a game. And one weekend when she was in LA, I started seeing all these text messages because she connected it to all her devices. So it just came up. I wasn't snooping or anything.
It's always the iCloud.
Yeah.
It gets you every time.
Every time.
All right, go ahead, sir. I think I know where this is going. Go
Yeah,
ahead.
and they were very odd text messages. These weren't like friends, and we have a lot of mutual friends, and I thought I knew everybody she
So
hung
what
out
were
with.
these messages saying, sir?
I have an example for you.
Oh,
here,
even
actually.
better.
Yeah.
Go ahead, offer up the cloud, sir. Let's see.
Thank you.
Thank you.
Yeah, I mean, a lot of these messages are things that, you know, they aren't like just a friendly variety.
Well, let's see what kind of people have different kind of friends. So let's see. You did not have to look that good tonight. Got me thinking some kind of way. Uh-oh, I dressed to impress you, and impress me you sure did. Please come over tonight. I'm lonely and need my best girl, Tay-Tay. I suppose, ma'am, you're Tay-Tay? Okay. I've told you to stop calling me Tay-Tay. Are you sure about that? Oh, my gosh, you dog. I'm going to pause you for a second. Ma'am, who is this?
His name's Jason. He's a friend from college, and we reconnected after Michael had moved to Denver. Michael knows I'm flirty. He knew that before going into the relationship. I'm just fun. I like to have fun.
Okay,
I like to joke.
You're
I like
telling the court, because this is important for my ruling, that this stayed in the group. This stayed in the text chain. This
Yes.
never got physical. This never came to any fruition.
Yes.
What do you think about that, sir?
Well,
VO 11. This distinction is critical. The court acknowledges emotional betrayal, but separates it from legal justification. Feelings do not create emergencies. While the judge respects the defendant's pain, she makes it clear that punitive timelines affecting animals cross a legal line. The law protects dependents, including pets, from retaliation. You cannot create financial consequences just to prove a point.
I don't know if it ever got physical, but for me, you know, you hit a certain age and you date with intention to be married to somebody, right?
Okay, come on, grown man.
And, you know, cheating from the heart is still cheating.
Okay, and so what did you do as a result?
I called her up the next
So
morning.
you immediately confronted her?
And confronted her about it and said, it's over, come get your stuff. Pick
Oh,
up
so
the
you were
dogs."
done?
Judge Ebony's verdict when Equal Justice returns. This is Equal Justice.
So you ended it. You didn't want to hear anything from her at this point.
No.
Did you, though, tell her that you were going to kick out her dogs and her things out of your apartment?
I did.
You did do that?
I did.
I felt very manipulated, Your Honor.
Okay. And what was the timeline that he said he would give you to come get him?
He had said by the end of the week, and in that situation, it was about 2 days.
Okay, so you had 48 hours. come get the dogs and get the dogs and your stuff out of his unit.
That's correct.
Okay, and were you able to accommodate it?
Just in time. It
Okay,
was
and
about
that's
2
why
days.
you're saying that you had to spend the extra $778 to make this happen in his time frame.
Correct.
All right, with all that said, I think I'm ready to rule on this matter. What I do know for sure is, ma'am, you've asked this court to reimburse you for the expenses of an acute, accelerated dilemma where you've got to save the well-being of your animals. Sir, the court has found that you made up that whole artificial scenario because you felt a way. And while the court can understand your feelings, you're going to have to bear the cost, quite literally, of manufacturing an emergency when an emergency really did not exist. The court finds in favor of the plaintiff to her full ask, $778. That's my ruling.
Today's courtroom delivered two powerful lessons. In the first case, the court reaffirmed that history does not excuse harm, and property rights end where documented suffering begins. In the second, emotional betrayal did not justify manufactured urgency or financial pressure. Judge Ebony K. Williams ruled consistently. Evidence matters, intent is examined, and accountability follows actions, not excuses. These cases remind us that justice isn't about who feels right. It's about who proves harm. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your support helps us keep bringing you the truth behind the verdicts.